Greetings again. This is our second lecture on Chapter 2 for Criminal Justice 315, Criminal Evidence. In today's chapter, we're talking about the role of the courts. This is my bread and butter. This is what I'm involved in. This is why you become an attorney. You like to know about the courts. You like to know about the judicial branch of the government. Yeah, the executive branch, they're fine. They enforce the law. The legislative branch, they create the law, but it's the judicial branch that lawyers really like, because that's where we get that's where you get to play around with the law. That's if you imagine a sandbox with all the toys are the law, and the lawyers are the kids. They get to go in there and they get to play around with all those toys. We get to say, what's a cool toy and what's a bad toy. That's really what the role of the courts are doing. So in a nerdy way. So that's what we're going to be talking about here today. And right off the bat, let's just go ahead and talk about this idea of checks and balances. Many of you have heard that Civics 101 here, executive branch, legislative branch, judicial branch. That's the way that our United States government is set up. Again, as I mentioned, legislative branch writes the law. Whatever that law is that's being written, the executive branch enforces it because they are the enforcer of the law. And then the judicial branch, well, it's their duty to say what the law is. What I mean by that is they say whether or not it's a good law, meaning it's constitutional, and whether or not it's bad law. There's misconceptions sometimes that the courts can make stuff up. There was a time where that was true, but for the most part, because we have checks and balances, it's really the role of the court to interpret the law. And sometimes that interpretation does feel like, when the courts make that interpretation of the law, it does feel like they're making stuff up. But again, that's not really the case, because the court itself, they have what's called principles of interpretation. And those are the things that but actually kind of set the boundary for the court. And if you want to interpret something, you have to do it within this boundary. These are the rules that you have to do it in. As part of being the judicial branch, they have to be independent. The executive branch and the legislative branch, sometimes they merge in certain areas. They have some areas where they definitely do merge. And the one that you probably are more familiar with than anything else is this idea that the president is the commander-in-chief of the armed forces, and it is the Congress's job to declare war. And that's really where there's a merger, there's an overlap, because the president can send our troops across seas into a foreign sovereign and start a war, but he can't declare war. So that can look like a war, it can smell like a war, it can create other wars around the world, but it can't be called a war. That's Congress's job. But yet, it can get very confusing. So there's that overlap. There's no overlap with the judicial branch. They are completely and wholly separate. They aren't even on the same block as the legislative and executive branch of the government. So it's important to understand that. And that's the other thing that's why lawyers really like it. We kind of feel like we have our own kind of special clubhouse. It's like, you can just set it up and write your rules. You are not allowed in here, right? You have to be able to do this. You have to have this license. You have to do this in order to enter, right? So, and with that, let's talk a little bit about, so what happens once whatever the president, or not the president, the executive branch or your legislative branch, whatever they do, finally makes its way over to the judicial branch. Whatever they do, if it finally makes it over there to the judicial branch, that building, and it walks in the door, usually it just can't go straight to the highest top of the judicial branch of the government, right? Let's assume we're in the United States government. It can't just go straight to the top. It goes to the very bottom, and it can work its way up. What's at the very bottom? The district court. Usually every lower level court is called district court. There's small claims court, but don't worry about that, or magistrate court. We're talking about district court. That's usually your lowest level. After that, some states have an immediate court that's called maybe a superior court, something that's still a small level court, but they hear maybe a different style of case that district court hears. For example, district court may hear misdemeanors and superior court may hear felonies. But once they are appealed, they both go straight up. That's one system. Another system is district court hears everything, and then if you want to appeal, you go to the superior court where there's a little bit more sophisticated level, more detailed review of the case. Then after superior court, then you go up another level, and then another level, another level. Well, let's look at this in practical terms. In West Virginia, there's really two levels of court. That's it. There's a district court, and then there's an immediate appeal to the West Virginia Court of Appeals, Supreme Court of Appeals. That's not the way it works in North Carolina. In North Carolina, there is a district court, and then there is a superior court. Then there's a court of appeals, and then there is a North Carolina Supreme Court. That is how North Carolina's judicial system is set up. Now, both judicial systems, and we're going to look at North Carolina and West Virginia, operate in very similar ways. One of those being is that most of the judges are elected officials. Now, we talked about in chapter 1 how prosecutors are elected officials, but now we're learning that judges are elected officials, and that is absolutely true. They are elected officials, and some serve 4-year terms, some serve 8-year terms, and some serve 12-year terms. In West Virginia, the Supreme Court justices there, they serve 12-year terms. And that's actually the same amount of time that North Carolina Supreme Court justices serve. They serve 12 years. But North Carolina's intermediate court, the Court of Appeals, they're not called justices, they're called judges. They serve 8-year terms. And then our judges below that serve 4-year terms. So you can kind of see that kind of breakdown. Each court system serves a certain geographic location. So the Mineral County Courthouse serves all of Mineral County. The Mineral County District Courthouse down there in downtown Kaiser, that serves all of Mineral County. Now, there might be different other counties have different courthouses, so you can't be in Grant County and try to initiate some sort of criminal process unless the criminal process occurred elsewhere. Otherwise, it needs to be done in Grant County. Same thing goes with Mineral County. Wherever the crime occurred, it has to be there. As I said before, if you don't like the result in the district court level, you appeal it. In West Virginia, it will go straight to the Court of Appeals. That's why they have a very backlog system. In North Carolina, it's a little bit different. Misdemeanors will be heard in district court. Felonies go straight to superior court. If a misdemeanor is appealed in district court, it goes to superior court. The superior court will review the misdemeanor, and then it will go to the intermediate Court of Appeals level if it reaches that high. A couple of things that kind of stop a court from hearing a case is a thing called a statute of limitations. And the statute of limitations are a time bar, meaning that in order to initiate some sort of action, you have to do it within this time period. Now, for statute of limitations, they operate a little bit different in the criminal system. In the civil system, you have to be really, really keep a keen eye. I mean, you have to pay serious attention to detail on your statute of limitations in civil because the stakes aren't as high. So we kind of feel like we don't want this civil case to hang around forever. Breach of contract, you know when there's a breach, and because it's a relatively small thing, it's not very big. We're only going to give you a little bit of time to do it. But for criminal cases, we're going to leave that door open a little bit longer, especially for murder. At common law, for murder, there used to be the year and a day rule, and I don't know if you're familiar with that, but at common law, there was this idea that if the person died 1 year and a day after the act, then that person who committed the act can't be tried for murder because statute of limitations ran. But now, most states, all states, have done away with that. Now the statute of limitations, they're infinite. At any point in time, causation, there's this thing called causation, but at any point in time, someone can be put on murder even if the act that gave rise to the murder happened 10 years ago. So that plays as a function as more of a balance on the court. We can't hear this case because it's been too long. Now, when we talk about we talk about the federal rules of evidence. We talk about in chapter 1 that they're used to kind of filter out the evidence and what comes into courts. There's another thing that kind of affects what comes into the courts as well, and that's called case law. And case law is what is declared or held by intermediate appellate levels. So anything from the Intermediate Court of Appeals to the Supreme Court, that could be the state Supreme Court or the United States Supreme Court, can have an effect on what comes into a courthouse, into a court case, or whether or not the court actually even hears the case. The biggest example you've ever heard of, the most widely known, is probably this idea of the fruit of the poisonous tree doctrine. This was a case law doctrine announced by the United States Supreme Court that said that any item that is seized pursuant to an invalid search or seizure in violation of the Fourth Amendment is inadmissible in court because it is considered fruit of the poisonous tree. The poisonous tree being the initial invalid search or seizure, and anything obtained after that is fruit of the poisonous tree. That is a case law doctrine. That is not something that a statute was created for. That is not a rule of evidence. That is a case law doctrine that the United States Supreme Court announced. And it's also a constitutional law doctrine. So it reigns supreme. That was part of the judicial's function of saying what's good and what's bad, what's constitutional and what's unconstitutional. They said it was unconstitutional for the officers to perform this search. Therefore, anything obtained in violation throughout that search was fruit of the poisonous tree. That's how it operated. And we're going to talk about that more down the line. But that's how you understand case law. So some things that kind of put the court in balance. One, they don't make law. Legislative branch makes law. The second thing, they don't enforce the law. The executive branch enforces the law. The third thing, the statute of limitations. Those things operate as barriers on the court's role, makes them an independent and puts balances on them. Other things that affect them. Case law. Whatever the case law says also limits the court's power. So I'm trying to make sure that I've covered everything that I think you need to understand about this chapter. And pretty much that is everything that I think is really important to hit on for this chapter. Please remember that you're still responsible for everything in chapter 2. There are a lot of things in here about the roles of the United States Supreme Court. There's a lot of things about there's some things about post-conviction proceedings that are in here that you should know. But I wanted to make sure that I hit on these topics because they're basic foundation topics that are going to be used further on as we discuss these other chapters, and that I will be referencing back to at later time. If you have any questions, please reach out to me. I'm more than happy to answer your questions. Have a wonderful day, and I'll see you next time.